This documentary provides a comprehensive explanation of family-based immigration in the United States. We will examine who may sponsor family members, who qualifies for immigration benefits, the difference between immediate relatives and family preference categories, how visa availability affects waiting times, and the complete process from filing a petition to receiving permanent residence. Along the way, we will also explain common legal terms, government forms, financial sponsorship requirements, and the mistakes that most often delay or prevent approval. This documentary focuses specifically on family-based immigration under United States immigration law. Immigration laws change over time, and individual circumstances can significantly affect eligibility and processing. While this documentary explains the legal framework in depth, it is intended for educational purposes and should not be considered legal advice. Instead, our goal is to help you understand how the system works, so you can better navigate the process and recognize when professional legal guidance may be appropriate. Before we explore the different categories of family sponsorship, it is important to understand the principles that shape America's immigration system. The foundation of today's system is the Immigration and Nationality Act, commonly known as the INA. This federal law defines who may immigrate to the United States, who may sponsor a family member, and what legal requirements every applicant must satisfy before receiving permanent residence. U.S. Citizenship and Immigration Services reviews petitions and applications. The Department of State processes immigrant visas through American embassies and consulates around the world. U.S. Customs and Border Protection oversees lawful admission at ports of entry. Together, these agencies carry out the immigration laws enacted by Congress. Congress, not the President, creates the immigration categories that determine who may immigrate through family relationships. Congress enacted sweeping reforms to the Immigration and Nationality Act. Those reforms moved the United States away from a system based primarily on national origin and placed far greater emphasis on something else: family relationships. But even within the family immigration system, not all relatives are treated the same. Congress created two distinct pathways. The first is the category of immediate relatives of United States citizens. These cases receive the highest priority under the law and are generally not subject to annual numerical visa limits. The second pathway consists of the family preference categories. These include certain relatives of U.S. citizens and lawful permanent residents. But unlike immediate relatives, these visas are limited each year by Congress. When the number of applicants exceeds the number of available visas, as it often does, waiting lists begin to grow. For some families, the wait may be measured in months. For others, it can last many years, sometimes even decades. Understanding why those differences exist is one of the keys to understanding the entire family immigration system. In the chapters ahead, we'll build on this foundation, one step at a time. Every family-based immigration case begins with one fundamental question: who is the sponsor? Not everyone living in the United States has the legal authority to petition for a relative. Immigration law reserves that privilege for specific individuals who meet clearly defined legal requirements. In most cases, only two groups may sponsor eligible family members: United States citizens and lawful permanent residents, commonly known as green card holders. Although both may petition for certain relatives, the law grants them very different sponsorship rights. The sponsor's immigration status determines not only who may be sponsored, but often how long the immigration process will take. One of the most common misconceptions about family immigration is that throughout the immigration process, you'll encounter two important legal terms. The petitioner is the person filing the immigration petition. The beneficiary is the family member seeking the immigration benefit. Understanding these terms now will make every form, notice, and decision much easier to follow. United States citizens have the broadest sponsorship authority under the law. They may petition for spouses, parents, children, married sons and daughters, and brothers and sisters. Some of these relatives qualify as immediate relatives and are generally not subject to annual visa limits, while others fall into the family preference system and may wait years before a visa becomes available. Lawful permanent residents also have the ability to reunite with family, but Congress has placed important limits on that authority. In general, permanent residents may petition only for their spouses and unmarried children. They cannot directly sponsor parents, married sons or daughters, or siblings. For many families, becoming a U.S. citizen is more than a personal milestone. It also expands the opportunities to reunite with loved ones. Regardless of immigration status, every sponsor must establish the qualifying relationship, submit the required forms and evidence, and, later in the process, often demonstrate the financial ability to support the intending immigrant. Careful preparation at the beginning can prevent delays and complications later. Maria is a U.S. citizen. Her husband lives in Mexico, her mother in Peru, her brother in Colombia, and her married adult son in Spain. Can she sponsor them? Yes. But each relationship is treated differently under the law. Some qualify as immediate relatives, while others fall into the family preference categories with very different waiting times. Understanding those distinctions is the next step in mastering America's family-based immigration system. Throughout this documentary, we've referred to a special group known as immediate relatives. But despite the name, this category is often misunderstood. Immediate relative is not simply a description of a close family member. It is a legal classification created by Congress. Under the Immigration and Nationality Act, only 3 groups qualify: the spouse of a United States citizen, the parent of a U.S. citizen who is at least 21 years old, and a qualifying unmarried child of a U.S. citizen. These relationships receive the highest priority under family-based immigration because they are generally not subject to annual numerical visa limits. That means they can usually move forward as soon as the petition is approved, without waiting years for a visa number to become available. The phrase immediate relative can be misleading. It does not mean the immigration process happens immediately. Every applicant must still complete background checks, medical examinations, interviews, and all other legal requirements. The advantage is that immediate relatives are generally exempt from the visa backlogs that affect many other family-based categories. The largest immediate relative category is the spouse of a United States citizen. To qualify, the marriage must be legally valid and entered into in good faith. Immigration officers carefully examine the evidence to ensure the relationship is genuine. Joint financial records, shared residences, photographs, travel together, and other documentation help demonstrate that the marriage is real. Fraudulent marriages carry serious immigration and criminal consequences. But for legitimate couples, this category offers one of the most direct paths to permanent residence. Some spouses receive conditional permanent residence rather than a standard 10-year green card. If permanent residence is granted before the second wedding anniversary, the immigrant generally receives a 2-year conditional green card and must later file a petition to remove those conditions. This process helps preserve the integrity of the immigration system while allowing genuine families to establish their lives together in the United States. Parents also qualify as immediate relatives, but only when their sponsoring son or daughter is a United States citizen who is at least 21 years old. Congress established this age requirement to ensure that the sponsoring child has reached adulthood before assuming the legal responsibilities of sponsorship. Immigration law also uses a very specific definition of the word child. Beyond biological children, the law recognizes certain stepchildren, adopted children, and children born outside of marriage, provided they satisfy the statutory requirements. For example, a stepchild may qualify if the marriage creating the step-parent relationship occurred before the child's 18th birthday. These details matter because a single fact can determine whether a person qualifies as an immediate relative or must seek immigration through a different category. Consider the Chen family. David, a US citizen, wishes to sponsor his wife May, his father in Canada, and his stepson Alex, who became part of the family when David married May before Alex turned 18. Each relationship may qualify under the immediate relative category, but each requires its own evidence and documentation. In family-based immigration, establishing the relationship is only the first step. Demonstrating that relationship through credible evidence is what allows the legal process to move forward. As we continue through this documentary, we'll leave the immediate relative category behind and turn to the part of the immigration system where waiting times, annual quotas, and priority dates become central to the process. The family preference categories. We have now seen the fastest side of family-based immigration, the immediate relative system. But what happens when the family relationship is real, the petition is valid, and the sponsor is eligible, yet the law does not provide an immediately available immigrant visa? This is where the family preference system begins. It is the second major half of family-based immigration. And for millions of families, it is also the part of the system that creates the longest waits. Unlike immediate relatives, these family members are subject to numerical limits established by Congress. That means there may be far more qualified applicants than there are immigrant visas available in a particular year. When that happens, a line forms. And in immigration law, that line is not simply measured by the date you applied. It is organized through something called a priority date. That concept will become one of the most important ideas in this entire documentary. Congress divided the family preference system into 5 principal categories. F1 covers unmarried sons and daughters of US citizens who are 21 years of age or older. F2A covers spouses and qualifying children of lawful permanent residents. F2B covers unmarried sons and daughters of lawful permanent residents who are 21 or older. F3 covers married sons and daughters of US citizens. And finally, F4 covers brothers and sisters of adult US citizens. 5 categories. 5 different family relationships. And 5 different places in the immigration queue. The category into which a family member falls can dramatically affect how long that person may have to wait for an immigrant visa. Let's begin with F1. This category covers the unmarried sons and daughters of US citizens who are 21 years of age or older. Notice the word unmarried. That word matters. A US citizen may have a 25-year-old daughter. If she remains unmarried, she may fall into the F1 category. But if she marries, her classification changes. She may move into the F3 category, which is reserved for married sons and daughters of US citizens. This illustrates something fundamental about family immigration. A change in family circumstances can change the immigration category. And when the category changes, the waiting period can change with it. Next comes F2A. This category covers the spouses and qualifying children of lawful permanent residents. And here, we encounter an important difference between citizens and green card holders. A US citizen's spouse generally falls into the immediate relative category. But the spouse of a permanent resident does not. Instead, that spouse is generally classified as F2A. The same broad distinction applies to qualifying children of permanent residents. Because F2A is a numerically limited category, visa availability must be considered. This is one reason the decision to become a US citizen can have significant consequences for family immigration. When a permanent resident naturalizes, the spouse and qualifying children may no longer be in the same preference category. The law may provide a different and potentially more favorable path. Then there is F2B. This category is for unmarried sons and daughters of lawful permanent residents who are 21 or older. Again, the word unmarried is critical. If the beneficiary marries while being sponsored in F2B, the underlying eligibility can be affected because permanent residents generally cannot petition for married sons and daughters. This is one of the reasons applicants must understand that family immigration is not simply a waiting game. Life continues while the petition is pending. People marry. Children are born. Parents naturalize. Families move. And every one of those events can potentially affect an immigration case. The F3 category covers the married sons and daughters of US citizens. Unlike F1, there is no unmarried requirement here. Marriage is actually what places the beneficiary into this category, but there is a trade-off. Because F3 visas are numerically limited, applicants may face substantial waits before an immigrant visa becomes available. And the principal beneficiary is not necessarily the only person affected by that wait. Under the family preference system, certain spouses and children may be entitled to derivative immigration benefits and may accompany or follow the principal beneficiary, subject to the applicable requirements. In other words, One family petition can potentially involve an entire family unit. Finally, we reach F4, the sibling category. A US citizen who is at least 21 years old may petition for a brother or sister. For many families, this category represents one of the longest waits in the entire family-based immigration system. Why? Because demand is enormous, while the number of visas available to the category is limited. The result is a queue that can stretch across many years. And this is where the difference between filing a petition and having an available immigrant visa becomes especially important. A family may receive an approved I-130 and still have to wait years before the beneficiary can actually obtain permanent residence through that preference category. So why does the government create these waiting lines in the first place? The answer is numerical limits. Congress has established annual limits for family-sponsored preference immigrants. For fiscal year 2026, the worldwide family-sponsored preference level is 226,000. But those numbers are distributed among the different preference categories according to the structure established by immigration law. There are also limits on how many preference visas may generally be allocated to nationals of a particular country in a fiscal year. When demand exceeds the available supply, the category becomes oversubscribed. And when that happens, the government must determine which applicants receive visas first. That is where the priority date becomes critical. This distinction is so important that it deserves to be repeated. An approved Form I-130 establishes that the government recognizes the qualifying family relationship. It does not necessarily mean that an immigrant visa is immediately available. For preference categories, the beneficiary may have to wait until their priority date becomes current. This is why someone can truthfully say, "My petition was approved years ago, but I am still waiting for my green card." The petition may already be approved. The visa may simply not yet be available. How does a family know when that visa may become available? Each month, the Department of State publishes the Visa Bulletin. The bulletin provides dates for the various family-sponsored preference categories and countries of chargeability. The categories appear as F1, F2A, F2B, F3, and F4. The countries are also divided into columns when separate limits apply. An applicant compares the relevant date in the Visa Bulletin with the case's priority date. If the priority date is earlier than the applicable final action date, the immigrant visa may be available for final action, assuming all other requirements are satisfied. The dates can move forward, they can remain unchanged, and sometimes they can move backward. That backward movement is known as visa retrogression. We will examine the Visa Bulletin and priority dates in much greater detail in a later chapter. Now let's return to the Martinez family. Maria is a US citizen. Earlier we saw that her husband Carlos and her mother Elena could qualify as immediate relatives. But Maria also has a brother Diego and a married adult son Javier. Diego falls into F4. Javier falls into F3. Maria has successfully established the qualifying family relationships. But that is not enough to tell us when either relative can immigrate. Their petitions enter two different preference categories, two different numerical limits, two different queues, and potentially two very different waiting periods. Now imagine that Javier's circumstances change. He and his spouse have a child while they are waiting. That child may potentially be included as a derivative beneficiary if the applicable requirements are satisfied. Then imagine the sponsor's circumstances change in another family. A permanent resident may become a US citizen, potentially changing the immigration category available to certain relatives. This is why family immigration is not simply about filing a form. It is about understanding how relationships, categories, numerical limits, and time interact. Let's put the entire family preference system into perspective. F1. Unmarried adult sons and daughters of US citizens. F2. A. Spouses and qualifying children of permanent residents. F2B. Unmarried adult sons and daughters of permanent residents. F3. Married sons and daughters of US citizens. And F4. Brothers and sisters of adult US citizens. 5 categories. 5 different legal relationships. And behind each one is a system of numerical limits and priority dates. Once you understand these 5 categories, the basic architecture of family-based immigration becomes much easier to see. But one major question remains. How does the government decide whose turn it is? That question leads us to one of the most important concepts in the entire immigration system, the priority date. If the government knows everyone's place in line, why can't everyone simply receive a visa when the petition is approved? Because Congress has placed numerical limits on many family-sponsored immigrant visas. There are only so many preference visas available in a fiscal year. When the number of qualified applicants is greater than the number of available visas, the government must establish a cutoff. Applicants whose priority dates fall before that cutoff may move forward. Those whose dates fall after it must continue waiting. This is why the Visa Bulletin exists. It is, in effect, the government's monthly window into the immigration queue. Every month, the Department of State publishes the Visa Bulletin. For family-sponsored preference cases, the Bulletin organizes visa availability by category and by country or area of chargeability. The 5 categories we examined in the previous chapter appear again. F1, F2A, F2B, F3, and F4. But now they are connected to dates. And this is where immigration terminology can become confusing. Because the Visa Bulletin contains 2 different sets of dates. The first is called the final action date. The second is called the date for filing. Let's begin with the final action date. Think of this as the date that answers the question, when can the immigrant visa or permanent residence actually be approved, assuming everything else is in order? For an oversubscribed category, the Department of State publishes a cut-off date. If your priority date is earlier than the applicable final action date, a visa number may be available for your case, subject to all other requirements. If your priority date is later, you generally must continue waiting. And there is an important detail. When the Visa Bulletin says C, that means the category is current. In a current category, visa numbers are available to all qualified applicants, subject to the other requirements. Now we come to the second date, the date for filing. This date can allow certain applicants to begin submitting documents, or, when USCIS authorizes its use for adjustment of status, to file the next application earlier than the final action date would permit. Think of it as an earlier checkpoint. The government is essentially saying, your visa may not be ready for final approval yet, but your case is close enough that we want you to begin preparing, or, where permitted, filing the remaining documentation. But there is a critical warning. You cannot simply choose whichever chart you prefer. For adjustment of status cases, USCIS determines each month whether applicants may use the Dates for Filing chart or must use the Final Action Dates chart.
Let's make this practical.
Imagine a beneficiary in the F3 category with a priority date of June 1st, 2012. Now imagine that in a particular month, the Visa Bulletin lists a final action date of May 15th, 2012, and a date for filing of March 1st, 2013. The beneficiary's priority date falls after the final action date. So the immigrant visa cannot yet be finally approved based on visa availability. But the priority date falls before the date for filing. If the applicable filing rules permitted, the beneficiary may be able to take certain next steps before the visa becomes available for final action. The important lesson is simple. The two dates can be different because they serve different purposes. There is another layer to the system. Your immigration waiting line can depend not only on your family category, but also on the country to which your visa is charged. This is generally referred to as the country of chargeability, which in many cases is connected to the country of birth. The Visa Bulletin normally has a column for most countries combined, called All Chargeability Areas except those listed. But certain countries with particularly high demand may have separate columns. In recent visa bulletins, those separately listed countries have included China, mainland-born, India, Mexico, and the Philippines. This means two people with the same family relationship and the same priority date can potentially face different visa availability depending on their chargeability. Why does country of chargeability matter? Because Congress has also established limits affecting the distribution of preference immigrant visas among countries. When demand from a particular country is especially high, the number of available visas can be insufficient to satisfy everyone immediately. The result is another queue, and that queue can become significantly longer than the queue for applicants from countries with lower demand. This is one reason immigration wait times cannot be reduced to a single number. There is no universal family immigration waiting period. The answer depends on several variables: the family category, the priority date, the applicant's country of chargeability, the number of visas available, and the amount of demand in the system. Now imagine something that can be particularly frustrating for families. You've been waiting. Your priority date moves closer, and then suddenly the date moves backward. This is called visa retrogression. Retrogression occurs when demand for available visa numbers becomes greater than expected, requiring the government to move a cutoff date backward to remain within the numerical limits established by law. The result can be confusing. A person may believe they are almost ready to receive a green card, only to discover that their category has moved backward. Retrogression does not necessarily mean that the petition has been denied. It means that visa availability has changed, and the waiting line has temporarily moved in the wrong direction. There is one more distinction every family should understand. A priority date is not a promise. It does not guarantee that a visa will be issued on a particular date. It establishes the applicant's place in the preference system. Visa availability depends on congressional numerical limits, demand, country allocation rules, and the government's monthly determination of cutoff dates. That is why immigration attorneys and applicants watch the Visa Bulletin so closely. It is not simply a chart. For many families, it is the calendar that determines when the next chapter of their immigration journey can begin. Let's look at a real example. The August 2026 Visa Bulletin illustrates just how different the waiting lines can be. For applicants in the general chargeability group, the final action date for F1 is December 15th, 2018. For F2B, it is January 1st, 2018. For F3, it is May 15th, 2012. And for F4, it is September 1st, 2009. But those dates are not the same for every country. Mexico, for example, has substantially earlier cut-off dates in several categories. India has a different F4 cut-off. The Philippines has different dates as well. This is why simply searching the internet for family immigration wait time can be misleading. There is no single number. The real answer is found by identifying the category, the priority date, the country of chargeability, and the applicable Visa Bulletin chart. Let's return once again to the Martinez family. Maria's brother Diego is in F4. Maria's son Javier is in F3. Both petitions have been approved. Now their families check the Visa Bulletin. They don't simply ask, "Is my petition approved?" They ask 4 questions. What is my category? What is my priority date? What is my country of chargeability? And which Visa Bulletin chart applies? Only after answering those questions can they determine whether their case is approaching visa availability. This is the difference between understanding immigration paperwork and understanding the immigration system. At this point, we can see the architecture of family-based immigration taking shape. We know who may sponsor. We understand immediate relatives. We understand the 5 family preference categories. And now we understand the role of priority dates and the Visa Bulletin. But there is still a crucial question. How does a family actually begin the process? What form must be filed? What evidence is required? Where is the petition submitted? And what happens after the government receives it? The answer begins with one of the most important forms in family immigration, Form I-130, Petition for Alien Relative. That is where our journey continues. We have spent the first part of this documentary understanding the architecture of family-based immigration. We know who can sponsor. We know which relatives qualify. We understand immediate relatives. We understand the family preference categories. And we now understand priority dates and visa availability. But how does a family actually enter this system? For most family-based immigration cases, the journey begins with a petition. Form I-130. Its official name is the Petition for Alien Relative. The form is filed by the qualifying family member in the United States, or, in certain circumstances, by a US citizen or lawful permanent resident living abroad. The purpose is straightforward: to ask the US government to recognize a qualifying family relationship under immigration law. But that simple purpose hides an important distinction. The I-130 is not a green card application. It is not an immigrant visa. And approval of the I-130 does not automatically give the beneficiary lawful permanent resident status. It establishes the family relationship that allows the case to proceed. Before completing a single field on the form, 2 people must be clearly identified: the petitioner and the beneficiary. The petitioner is the family member asking the government to recognize the qualifying relationship. The beneficiary is the relative who may ultimately seek the immigration benefit. critically important because the I-130 asks for detailed information about both people. Names, dates of birth, addresses, citizenship, immigration history, family relationships, and other identifying information. A mistake in one person's information can create confusion throughout the entire case. This is why the I-130 should not be treated as a simple form to fill out. It is the foundation of the immigration record. The first question is eligibility. Who can actually file the petition? As we have already seen, US citizens may petition for a broader range of qualifying relatives. Lawful permanent residents have more limited family sponsorship rights. The relationship selected on the I-130 must correspond to a category authorized by immigration law. For example, a US citizen may file for a spouse, parent, child, married son or daughter, or sibling, assuming the applicable requirements are satisfied. A lawful permanent resident may generally file for a spouse or qualifying child. The form itself asks the petitioner to identify the relationship: spouse, parent, child, or brother or sister. That selection is not merely administrative. It determines the legal basis for the petition and, in many cases, the preference category that follows. Next comes another fundamental question. Who are you? Before the government can approve a family petition, the petitioner must establish the immigration status that gives them the authority to file it. For a US citizen, acceptable evidence can include a US birth certificate, naturalization certificate, certificate of citizenship, consular report of birth abroad, or an appropriate US passport. For a lawful permanent resident, evidence generally includes the front and back of the permanent resident card. The principle is simple. Before the government evaluates the family relationship, it must know that the person filing the petition actually has the legal status required to file it. Now we reach the heart of the petition: the family relationship. The government does not simply accept a statement that two people are related. The relationship must generally be documented. For spouses, that may begin with a marriage certificate. For parents and children, birth certificates may establish the relationship. Stepchildren may require both the child's birth record and evidence of the marriage that created the step relationship. Adopted children may require adoption records and additional documentation. And if either person has previously been married, records showing the legal termination of those prior marriages may be required. The evidence depends on the relationship. There is no single document that proves every family relationship. The goal is to create a clear documentary chain connecting the petitioner and beneficiary. Marriage-based petitions deserve particular attention because the government is not only asking whether two people legally married,
It may also need to determine whether the marriage is genuine. A marriage certificate can establish that a marriage exists, but it may not, by itself, demonstrate the history and reality of the relationship. For that reason, couples may submit evidence such as joint financial accounts, leases, insurance policies, photographs, correspondence, travel records, or evidence of shared responsibilities. The goal is not to produce a scrapbook. The goal is to provide credible evidence that the marriage represents a genuine marital relationship, rather than a relationship created primarily to obtain an immigration benefit. The strongest cases generally tell a consistent story. The documents should support that story, and the story should be truthful. Immigration petitions contain a surprising amount of information. Names may appear in different forms, addresses may have changed, dates may be remembered differently. People may have used different surnames. Previous marriages may need to be disclosed. Children may live in different countries, and immigration histories may span decades. That is why consistency matters. The information on the I-130 should be consistent with the supporting documents and with the information provided later in the immigration process. A discrepancy does not automatically mean fraud. Sometimes mistakes are simply mistakes, but unexplained inconsistencies can create questions, delays, or requests for additional evidence. In immigration cases, accuracy is not a minor detail. It is part of the case itself. This is one of the most important concepts in family immigration. The I-130 is a petition. It establishes a qualifying family relationship. The actual process of becoming a permanent resident is a separate step. For someone applying from inside the United States, that may involve Form I-485, adjustment of status, if the person is eligible and a visa is available. For someone immigrating from outside the United States, the case may proceed through consular processing, including an immigrant visa application through the Department of State. The exact path depends on the beneficiary's circumstances, but the principle remains the same. An approved I-130 is not itself a green card. Once the petition has been completed and the supporting evidence assembled, the petitioner must submit it according to the current USCIS filing instructions. Depending on the circumstances and the form's current filing options, an I-130 may be filed online or by mail. The correct filing location and method matter. USCIS filing procedures can change, addresses can change, fees can change, and eligibility for online filing can depend on the type of petition. For that reason, families should always check the current USCIS Form I-130 instructions before submitting a petition. A petition sent to the wrong location, with the wrong fee, or with a required signature missing, can create avoidable problems in the very beginning of the process. A petition is not properly filed simply because the form has been completed. The submission must satisfy the applicable filing requirements. That includes the correct fee, required signatures, and the supporting evidence required for the particular relationship. The exact filing fee is something viewers should verify immediately before filing, because USCIS fees can change. This is an important principle for the entire documentary. Never rely on a fee shown in the video. The same rule applies to filing addresses, form additions, and procedural requirements. Immigration forms are living documents. USCIS periodically updates them. A professional immigration documentary should therefore teach viewers not only what to file, but also how to verify that the information is current. The family has finally submitted the petition. What happens next? First, USCIS must receive and process the filing. If the petition is accepted for processing, the petitioner generally receives a receipt notice. That notice is important. It confirms that USCIS has received the case and provides a receipt number that can be used to track the petition. For preference cases, the filing also establishes the priority date used in the immigration queue, assuming the petition is properly filed and accepted. From this point forward, the case has entered the federal immigration system. But entering the system does not mean the case is approved. USCIS must still review the petition. Now the waiting begins.
USCIS reviews the petition and the evidence submitted with it.
The government may determine that the evidence is sufficient. It may request additional evidence. It may identify a problem with the petition. Or, after review, it may approve or deny the petition. An approval means that USCIS has determined that the petitioner established the qualifying relationship and satisfied the requirements for the petition. But remember what approval does not mean. It does not necessarily mean the beneficiary can immediately enter the United States. It does not necessarily mean a visa number is available. And it does not automatically grant permanent residence. For a preference category, the family may still have to wait for the priority date to become current. For an immediate relative, the visa number is generally immediately available, but the beneficiary must still complete the remaining immigration process. The petition is approved. The journey continues. What happens after I-130 approval depends heavily on where the beneficiary is and whether an immigrant visa is available. If the beneficiary is outside the United States, the case may proceed through the Department of State and the National Visa Center before an immigrant visa interview at a U.S. embassy or consulate. If the beneficiary is inside the United States and otherwise eligible to adjust status, the case may proceed through USCIS using the adjustment of status process. And if the case is in a preference category where the priority date is not current, the family may simply have to wait. This is why the I-130 is best understood as a gateway. It establishes the relationship. It places the case into the appropriate immigration framework. And then, the next door opens. Let's return to the Martinez family. Maria is a U.S. citizen. She wants to bring her husband Carlos, who lives in Mexico, to the United States. Maria prepares Form I-130. She identifies herself as the petitioner. Carlos is identified as the beneficiary. Maria provides evidence of her U.S. citizenship. She provides their marriage certificate. Because they are married, she also gathers evidence demonstrating their genuine marital relationship. She reviews the form, checks the supporting documents, confirms the current filing instructions, and submits the petition. The government receives it. A receipt notice arrives. Now Maria has something she did not have before. Not a green card for Carlos, not an immigrant visa, but a recognized immigration case based on their qualifying family relationship. Because Carlos is the spouse of a U.S. citizen, he falls into the immediate relative category. His case is therefore not waiting for an annual family preference visa number. But there are still additional steps before Carlos can become a permanent resident. And those steps depend on the path he takes to immigrate. The I-130 has now done its job. It has established the qualifying family relationship. But the family immigration journey is far from over. For some families, the next step will involve the National Visa Center and a U.S. consulate abroad. For others, the next step may be adjustment of status inside the United States. And throughout that process, new forms, new documents, financial requirements, medical examinations, background checks, and interviews may enter the picture. The petition opened the door. Now we need to understand what lies on the other side. In the next chapter, we'll follow the two major pathways toward permanent residence: consular processing and adjustment of status has been established. The petition has been approved, and now the immigration journey reaches a critical decision point. Where will the beneficiary complete the process? For many people,
The answer depends on one basic fact. Are they applying from inside the United States or from outside the United States? For eligible beneficiaries already in the United States, the pathway may be adjustment of status. For beneficiaries who will immigrate from abroad, the pathway is generally consular processing. Two different processes, two different government agencies playing different roles. Two different sets of forms, but ultimately the same destination. Lawful permanent residence inside the United States. Adjustment of status, commonly abbreviated as AOS, allows an eligible person already in the United States to apply to become a lawful permanent resident without leaving the country for an immigrant visa interview abroad. The process is handled primarily by U.S. Citizenship and Immigration Services. The central form is Form I-485, Application to Register Permanent Residence or Adjust Status. But there is an important word in that description: eligible. Simply being physically present in the United States does not automatically make someone eligible to adjust status. Immigration status, how the person entered the United States, whether the person maintained status, whether a visa number is available, whether the person falls within an exception, and whether any bars or other legal restrictions apply can all matter. Adjustment of status is therefore not simply a matter of being inside America. It is a separate legal process with its own eligibility requirements. For an eligible applicant, Form I-485 becomes the central application for permanent residence. Unlike the I-130, which is filed by the petitioner to establish the family relationship, the I-485 is generally filed by the person seeking permanent residence. The roles have changed. The petitioner established the relationship. Now the beneficiary becomes the applicant for permanent residence. The I-485 asks for extensive information about the applicant: personal history, addresses, family information, immigration history, employment history, travel, and other information relevant to determining eligibility. This is the point where the government moves beyond the question, "Are these people related?" and begins asking, "Is this person legally eligible to become a permanent resident?" In some family-based cases, the I-130 and I-485 may be filed together. This is known as concurrent filing. It can be especially important in immediate relative cases because immigrant visas are generally immediately available to those beneficiaries. For certain preference categories, concurrent filing may also be possible when an immigrant visa is available under the applicable rules. But concurrent filing does not mean the two forms become one application. They remain separate immigration benefits. The I-130 asks the government to recognize the family relationship. The I-485 asks the government to grant permanent residence. Once the adjustment application is filed, the applicant may be scheduled for a biometrics appointment. At that appointment, USCIS collects information such as fingerprints and a photograph. The purpose is not to determine whether the family relationship is genuine. That was the primary purpose of the I-130. Biometrics serve another function: identity verification, background checks, and security screening. Many adjustment applicants must also complete an immigration medical examination. The examination is performed by a physician authorized under U.S. immigration rules. The purpose is not simply to determine whether someone is healthy. The immigration medical examination addresses specific health-related requirements established by immigration law. The physician completes the required documentation, and the results become part of the immigration case. For many applicants, The interview is the moment when the immigration process becomes very real. The applicant may be asked questions about their immigration history, their family, their marriage, their application, and the information submitted to USCIS. In marriage-based cases, the officer may ask questions designed to determine whether the marriage is genuine and whether the information in the application is accurate. Not every adjustment case follows exactly the same interview process. USCIS may waive an interview in some circumstances, but applicants should be prepared for one unless they know that it has been waived. If USCIS determines that the applicant is eligible, the adjustment application may be approved. At that moment, the applicant becomes a lawful permanent resident. The green card follows according to the government's procedures, but the exact nature of the permanent residence can depend on the circumstances. For example, certain spouses who have been married for less than 2 years when permanent residence is granted may receive conditional permanent residence. For others, the result is regular, lawful, permanent residence. The important point is that the applicant does not become a permanent resident simply because an I-130 was approved. Permanent residence is granted through the appropriate immigration process. For adjustment applicants, that process is the I-485. Now let's return to the other side of the road. The beneficiary is outside the United States. Instead of adjusting status inside America, the beneficiary generally applies for an immigrant visa through the U.S. Department of State. This is known as consular processing. The process begins after the approved petition is transferred to the Department of State's National Visa Center, commonly called the NVC. The NVC creates the case and sends instructions to the applicant or designated contact. From this point forward, the Department of State becomes central to the processing of the immigrant visa. After USCIS approves the petition and the case reaches the National Visa Center, NVC creates the immigrant visa case. The applicant receives a welcome letter containing important information for accessing the case through the Department of State's Consular Electronic Application Center, or CEAC. CEAC becomes the family's digital workspace for much of the immigrant visa process. Through the system, applicants can manage fees, applications, supporting documents, and communications from the National Visa Center. The NVC process begins with required processing fees. For immigrant visa cases, the Department of State currently identifies 2 principal processing fees in the standard sequence: the Immigrant Visa Application Processing Fee and the Affidavit of Support Fee, when applicable. Once the payments are processed, additional parts of the case become available. But payment is only the beginning. The family must now build the documentary record needed for the immigrant visa interview. The central application in consular processing is Form DS-260, the Online Immigrant Visa Application and Alien Registration. This is the beneficiary's immigrant visa application. It is far more extensive than a simple travel form. The applicant provides information about personal history, family, addresses, education, employment, travel, and other matters relevant to the visa application. And accuracy is critical. The information on the DS-260 should be consistent with the petition, civil documents, and the applicant's actual history. Submitting the DS-260 does not mean the applicant has already been granted an immigrant visa. The application is reviewed as part of the consular process. Ultimately, the consular officer determines whether the applicant is eligible for the immigrant visa. Now, another major requirement enters the picture: financial sponsorship. In many family-based immigrant visa cases, the petitioner must submit an affidavit of support, generally using Form I-864. The purpose is to demonstrate that the intending immigrant has adequate financial support and is less likely to become primarily dependent on certain public benefits. The affidavit is more than a simple promise. It creates a legally significant financial obligation for the sponsor. The sponsor must meet the applicable requirements, or, when permitted, additional financial sponsors or household members may be involved. The applicant must also assemble the required civil documents: birth certificates, marriage certificates, divorce decrees, police certificates where required, passport biographic pages, and other documents depending on the applicant's circumstances and country. These documents allow the government to independently verify the information provided in the immigrant visa application. And because civil document requirements can vary by country, applicants must follow the Department of State's instructions for the country where the case is being processed. Once the required fees, forms, financial documents, and civil documents have been submitted, NVC reviews the case. If something is missing or unacceptable, the applicant may receive a message requesting additional information or corrected documentation. If the case becomes complete and an interview can be scheduled, NVC works with the appropriate U.S. embassy or consulate to schedule the immigrant visa interview. But an approved petition does not guarantee an immediate interview appointment. Interview availability depends on the capacity and scheduling of the embassy or consulate handling the case. Eventually, the day arrives. The beneficiary appears at the U.S. embassy or consulate for the immigrant visa interview. The consular officer reviews the application. The officer may ask questions about the applicant's identity, family relationship, immigration history, and eligibility. The interview is the point where the Department of State determines whether the applicant qualifies for the immigrant visa. If the officer approves the visa, the beneficiary is one step away from becoming a permanent resident. But there is still one final step. The applicant must actually be admitted to the United States as an immigrant. An immigrant visa is not itself the green card. It is the document that allows the approved immigrant visa holder to seek admission to the United States as a permanent resident. At the port of entry, U.S. Customs and Border Protection conducts the admission inspection. If the person is admitted as a permanent resident, the immigration journey reaches a major milestone. The person is now a lawful permanent resident of the United States. Let's step back and compare the two pathways. Adjustment of status generally takes place inside the United States and is handled through USCIS. Consular processing generally takes place through the Department of State for a beneficiary immigrating from abroad. Adjustment of status centers around Form I-485. Consular processing centers around Form DS-260. Adjustment cases may involve a USCIS interview. Consular cases involve an interview with a U.S. consular officer. And yet, both paths are trying to answer the same fundamental question. Is this person legally eligible to become a permanent resident of the United States? The destination is the same. The road is different. Let's return to Maria and Carlos. Maria is a U.S. citizen. Carlos lives in Mexico. Their I-130 has been approved. Because Carlos is outside the United States, their case proceeds toward consular processing. Maria and Carlos now follow the Department of State process. The case reaches the National Visa Center. They receive their welcome letter. They access CEAC. They pay the required fees. Carlos completes the DS-260. Maria prepares the financial sponsorship documents. Carlos gathers his civil documents. The case is reviewed. An interview is scheduled. Carlos attends the interview at the appropriate US consular post. If the immigrant visa is approved, Carlos receives his immigrant visa. He then travels to the United States. At the port of entry, CBP determines whether he may be admitted as a permanent resident. And once admitted, the long journey that began with an I-130 petition reaches its most important destination. Carlos becomes a lawful permanent resident of the United States. But there is one final lesson from these two pathways. Adjustment of status and consular processing may appear similar from a distance, but they are not interchangeable. Eligibility rules can differ. Procedural protections can differ. Travel considerations can differ. Immigration violations can have very different consequences depending on the pathway. And for some applicants, leaving the United States to pursue an immigrant visa abroad can trigger serious immigration consequences. That is why the question, should I adjust status or consular process, should never be answered simply by asking where the beneficiary happens to be today. The correct answer depends on the person's complete immigration history and legal circumstances. For some families, the distinction is straightforward. For others, it can be one of the most consequential decisions in the entire immigration process. A family relationship has been established. The petition has been approved. The beneficiary may even have an available immigrant visa. But there is another question the immigration system must answer. How will this new immigrant be financially supported? Congress created the Affidavit of Support requirement to address that question. In many family-based immigration cases, the petitioner must agree to accept financial responsibility for the intending immigrant. That commitment is made through Form I-864, Affidavit of Support. Under Section 213A of the Immigration and Nationality Act, and this is important, the I-864 is not simply a statement saying, "I promise to help my relative." It creates a legally significant financial obligation. The sponsor is making a formal commitment under federal immigration law. Why does the government require this commitment? One reason is to reduce the likelihood that an intending immigrant will become primarily dependent on certain public benefits for financial support. The government wants to know that the immigrant has a source of financial support after arriving in the United States. The Affidavit of Support provides that assurance. But the law goes further. The sponsor's obligation is enforceable under the applicable law. In certain circumstances, if the sponsored immigrant receives designated means-tested public benefits, the agency providing those benefits may seek reimbursement from the sponsor. This means the I-864 is not simply part of the immigration paperwork. It can have consequences long after the green card is issued. The person completing the Affidavit of Support is generally the petitioner. The same person who filed the I-130 usually becomes the financial sponsor. But the sponsor must satisfy requirements of their own. Generally, the sponsor must be at least 18 years old. The sponsor must be a US citizen or lawful permanent resident, and the sponsor must have a domicile in the United States. These requirements are separate from the income requirement. A person might have enough money, but still fail to qualify as a sponsor if they do not satisfy the other legal requirements. Likewise, a petitioner may satisfy the status and domicile requirements, but have insufficient income. The immigration system treats these as separate questions. The word domicile can sound deceptively simple. It does not merely mean, where are you physically located today? For immigration purposes, domicile generally refers to the sponsor's principal residence, with the intention of maintaining that residence for the foreseeable future. This becomes particularly important for US citizens and permanent residents living abroad. A US citizen may be temporarily living overseas and still maintain a US domicile. But someone who has permanently relocated abroad may have difficulty establishing the required domicile. In certain circumstances, a sponsor living abroad may establish that they intend in good faith to re-establish US domicile no later than the time the intending immigrant is admitted. Evidence might include US property, bank accounts, tax records, employment plans, or other continuing ties to the United States. The question is not simply, where do you live today? It is, where is your principal residence, and where do you intend to maintain it? Now we reach one of the most important calculations on the I-864, household size. Why does household size matter? Because the required income increases as the size of the household increases. The sponsor generally counts themselves, their spouse, certain children, people claimed as dependents on their most recent federal tax return, the intending immigrant, and qualifying derivative beneficiaries. Other people being supported under existing I-864 obligations may also need to be counted. And in certain circumstances, household members who are not dependents can be included if they qualify and sign Form I-864A. The calculation is therefore more complicated than simply counting the people living in the house. The form creates a specific legal definition of household size. Once household size has been established, the next question is income. For most sponsors, the required income is at least 125% of the federal poverty guidelines for the sponsor's household size. There is an important exception. Sponsors who are on active duty in the US Armed Forces and are sponsoring their spouse or child generally use the 100% threshold rather than 125%. The exact dollar amount changes as the federal poverty guidelines are updated. That means a documentary should never teach viewers to rely on a single income number forever. The household size matters. The sponsor's circumstances matter. And the applicable year's guidelines matter. Always check the current USCIS or Department of State guidance when completing the form. Income is not simply the amount appearing in a sponsor's bank account. The I-864 process looks at the sponsor's income under the applicable rules. Evidence may include federal tax information, employment records, pay statements, and other documentation demonstrating current income. The government is trying to answer a practical question. What financial resources does the sponsor actually have available to support the household? That is why a tax return alone may not tell the entire story. A sponsor may have changed jobs, received a promotion, lost employment, started a business, or experienced another significant change since the most recent tax return. Current income can therefore be an important part of the analysis. Now imagine the sponsor has a qualifying family relationship, but the income falls below the required threshold. Does that automatically end the immigration case? Not necessarily. The immigration system provides several mechanisms that may allow the financial requirement to be satisfied. The sponsor may be able to use qualifying household member income. Certain assets may be counted. Or a joint sponsor may agree to independently assume the required financial responsibility. Let's begin with household members. In certain circumstances, the sponsor can use the income or assets of qualifying household members. But the household member generally must formally agree to the obligation by signing Form I-864A, Contract between Sponsor and Household Member. This is more than a supporting statement. The household member accepts financial responsibility under the contract. What happens when household income still isn't enough? A joint sponsor may be the solution. The joint sponsor must independently meet the requirements to be a sponsor. That generally means being at least 18 years old, being a US citizen or lawful permanent resident, and having US domicile. Most importantly, the joint sponsor must independently meet the applicable income requirement for their own household size. They do not simply add their income to the original sponsor's income. Instead, the joint sponsor accepts a separate financial obligation by filing their own Form I-864. This distinction is extremely important. A joint sponsor does not replace the petitioner. The petitioner generally still must file the required affidavit of support and meet the non-income sponsor requirements. The joint sponsor supplements the case by independently meeting the financial requirement. Legal insight. A common misconception is that finding a joint sponsor solves every financial problem. It does not. The petitioner still has to satisfy the basic requirements to be a sponsor. The joint sponsor must qualify independently, and the government may still examine the overall financial evidence submitted with the case. A joint sponsor is a mechanism for satisfying the income requirement, not a way to bypass the legal requirements of the affidavit of support. Income is not the only financial resource that may be considered. Under the applicable rules, certain assets may be used when income is insufficient. These can include qualifying savings, stocks, bonds, and certain real property. But an asset is not simply valued at whatever number the owner believes it is worth. The government generally looks at the net cash value of the asset. That means debts and liens must be considered, and the asset must generally be capable of being converted into cash within the required period without significant hardship or financial loss.
Special rules can apply to sponsors of spouses and children of US citizens. So assets can help, but they must be documented and valued correctly. Now we come to perhaps the most important part of this chapter. What exactly is the sponsor promising? By signing Form I-864, the sponsor accepts a legally enforceable financial responsibility toward the sponsored immigrant under the terms established by law. That obligation generally continues until one of several terminating events occurs. For example, the sponsored immigrant may become a US citizen. The immigrant may be credited with 40 qualifying quarters of work under Social Security law, generally corresponding to about 10 years of qualifying work. The immigrant may cease to be a lawful permanent resident and depart the United States permanently. Or another legally recognized terminating event may occur. And there is one particularly important misconception. Divorce does not normally terminate the I-864 obligation. The financial sponsorship obligation is separate from the marital relationship. A sponsor should therefore understand the commitment before signing. The affidavit of support is more than an immigration form.
It represents a legal commitment. The sponsor is telling the government, "I accept responsibility for financially supporting this immigrant under the law." That commitment is one reason the government requires detailed financial evidence. It is also why sponsors should not sign the form casually. Before signing, the sponsor should understand the household size, the income calculation, the assets being claimed, the tax documentation, the domicile requirement, and the potential duration of the obligation. A signature on the I-864 is not simply the final step in a stack of paperwork. It is a legal commitment with consequences. Let's return to Maria and Carlos. Maria is a US citizen. Carlos is immigrating from Mexico. Maria has filed the I-130. The petition is approved. Carlos is moving through consular processing. Now Maria reaches the financial sponsorship stage. She calculates her household size. She determines her qualifying income. And then she compares that income with the applicable federal poverty guidelines. Maria discovers that her income is below the required threshold. The case is not necessarily over. Maria examines whether qualifying household member income can be used. If that is not sufficient, she considers qualifying assets. And if those options still do not satisfy the requirement, Maria may need a joint sponsor. A family member or another qualified person may agree to become a joint sponsor and submit a separate I-864. Now the government has two financial sponsors, each with their own legal responsibilities. The lesson is important. A family petition can establish the relationship. An approved petition can move the case forward. But the financial sponsorship requirement must also be satisfied before the immigrant visa or adjustment process can be completed. One final distinction deserves attention. The Affidavit of Support is an important part of the government's assessment of financial support. But it is not the only financial consideration that may arise in an immigrant visa case. Consular officers may consider other factors relevant to the public charge analysis, including the applicant's age, health, education, skills, financial resources, and family circumstances. So, a sufficient I-864 does not mean that every other immigration requirement has automatically been satisfied. The I-864 addresses one major part of the financial picture. It does not eliminate the rest of the immigration law. We can now see why financial sponsorship occupies such an important place in family immigration. The family relationship establishes eligibility for the petition. The visa category determines the immigration pathway. The priority date determines when a visa may become available in preference cases. And the Affidavit of Support addresses another critical question. Can the immigrant be financially supported under the requirements of immigration law? These are not separate worlds. They are interconnected parts of the same immigration journey. A case can succeed at one stage and encounter a problem at another. That is why understanding the entire process matters. The family has now established the relationship. The petition has been filed. The immigration pathway has been identified. Visa availability has been considered, and financial sponsorship has been addressed. But there is still another layer to the journey. Documents can be missing. Forms can contain errors. Government agencies can request additional evidence. Applicants can encounter inadmissibility issues, and some cases can be delayed or denied. In the next chapter, we will examine the problems that can disrupt an otherwise valid family immigration case, and the mistakes families should understand before they begin. Because knowing the process is important, but knowing where the process can go wrong may be even more important. So far, our journey has followed the normal path: a qualifying family relationship, an I-130 petition, visa availability, financial sponsorship, and finally, the process toward permanent residence. But real immigration cases are rarely this clean. A document may be missing, a date may be inconsistent, a previous marriage may not have been properly documented, an applicant may have overstayed a visa, there may be a prior arrest, a previous immigration application may contain an inaccurate answer, or the government may simply need more information before making a decision. These problems do not all have the same significance. Some are administrative, some can cause substantial delays, and some can create legal barriers to immigration. This is why understanding the normal process is only half of the story. The other half is understanding what happens when something goes wrong. Let's begin with the simplest problem: a missing document. Perhaps the applicant submitted a birth certificate, but not the required translation. Perhaps a marriage certificate was submitted, but the evidence of a prior divorce was missing. Perhaps the financial documentation was incomplete. These problems can often be corrected, but they can also delay a case. The lesson is simple. A government checklist is not merely paperwork. Each document serves a purpose. The government uses documents to verify identity, family relationships, immigration history, financial sponsorship, and eligibility. When something is missing, the government may ask for it, and that request can change the timeline of the case. In many USCIS cases, if the evidence submitted is insufficient, USCIS may issue a request for evidence, commonly called an RFE. The message is essentially, "We need more evidence before we can decide your case." An RFE does not automatically mean the case is going to be denied. It means USCIS has identified information or evidence that it believes is necessary to adjudicate the application or petition. The response matters. The applicant or petitioner must follow the instructions carefully and provide the requested evidence within the specified time frame. A weak or incomplete response can create a much more serious problem. A well-prepared response may allow the case to continue. An RFE is not the same thing as a Notice of Intent to Deny, or NOID. A NOID is more serious. It means USCIS is indicating that, based on the information available, it intends to deny the petition or application unless the response establishes why the case should not be denied. The petitioner may be given an opportunity to respond with additional documentation or explanation. This is a critical moment. The response should address the government's specific concerns, not simply repeat the original submission. And when the issue involves complicated legal questions, professional legal advice may be particularly important. What if the government ultimately denies the I-130? That means USCIS has determined that the petitioner did not establish the requirements for the petition. The consequences depend on the reason for the denial. Perhaps the family relationship was not legally qualifying. Perhaps the evidence was insufficient. Perhaps the petitioner was not eligible to file. Or perhaps the government identified a more fundamental problem. An I-130 denial is therefore not simply a delay. It can prevent the case from moving forward on that petition. But even here, the correct response depends on the facts. Some cases may involve motions or appeals. Some may require a new petition. And some may involve issues that cannot be solved simply by submitting the same evidence again. The important lesson is, a denial is a legal decision, not merely a missing document notice. Now we move from petition problems to problems involving the beneficiary. A person may have a qualifying family relationship. The I-130 may be approved. The financial sponsorship may be sufficient. And yet the person may still be unable to obtain an immigrant visa or adjust status. Why? Because immigration law contains another major concept: inadmissibility. In simple terms, certain circumstances can make a person legally ineligible to receive an immigrant visa or, in applicable cases, adjust status. The grounds are numerous. They can involve health, certain criminal conduct, immigration violations, fraud or misrepresentation, security-related concerns, unlawful presence, and other statutory grounds. An approved family petition does not erase these grounds. This distinction is fundamental. The I-130 asks, is there a qualifying family relationship? The immigrant visa or adjustment process asks additional questions. Is this person eligible for the immigration benefit? And is this person admissible under US immigration law? These are different questions.
A person can win the first question and still encounter a problem with the second. This is why saying, "My I-130 was approved, so my green card is guaranteed," is incorrect. The I-130 establishes the family relationship. It does not erase every other requirement of immigration law. One of the most important immigration problems involving family-based cases is unlawful presence. Certain periods of unlawful presence in the United States can have consequences when a person later departs the country. Under the immigration law's 3-year and 10-year bars, departure after more than 180 days, but less than 1 year, of unlawful presence during a qualifying period can trigger a 3-year bar. Departure after 1 year or more can trigger a 10-year bar. These rules are complicated. Not every day physically present in the United States necessarily counts the same way. Exceptions can apply. The calculation can depend on age, immigration status, pending applications, and other legal circumstances. That is why unlawful presence should never be calculated casually from a calendar. For certain people who are physically present in the United States and are pursuing immigrant visas abroad, the law provides a mechanism known as the Provisional Unlawful Presence Waiver. The application is made on Form I-601A. The purpose is narrow. It addresses certain unlawful presence grounds of inadmissibility before the person leaves the United States for the immigrant visa interview. But the name of the form tells us something important. It is a provisional waiver of unlawful presence. It is not a waiver of every possible immigration problem, and approval of an I-601A does not guarantee that the immigrant visa will be issued. The applicant may still be found inadmissible on another ground. There is another waiver form, Form I-601, Application for Waiver of Grounds of Inadmissibility. Unlike I-601A, which is specifically designed for certain provisional unlawful presence situations, Form I-601 can apply to certain other grounds of inadmissibility when the law permits a waiver. Depending on the ground involved, the legal requirements can be very different. Certain health-related grounds may have waiver provisions. Certain criminal grounds may have waiver provisions. Fraud or misrepresentation may have waiver provisions in particular circumstances. And unlawful presence can also be subject to waiver rules. But not every ground of inadmissibility can be waived. And even where a waiver exists, the applicant must satisfy the legal standard for that particular waiver. This is why the word waiver should never be understood as meaning the problem can simply be forgiven.
A waiver is a specific legal remedy with specific requirements. Among the most serious problems in immigration law are allegations of fraud or willful misrepresentation of a material fact to obtain an immigration benefit. Imagine that an applicant previously gave false information to a US immigration officer or submitted materially false information in an immigration application. Years later, the person files a family-based immigration case. The old information may become relevant again. Immigration records follow the applicant, and an inconsistency that seemed insignificant years earlier can become extremely important when the government evaluates a new immigration benefit. This is why honesty is not simply good advice. It is a fundamental principle of immigration law. If there is a potentially significant discrepancy in an applicant's history, it should be identified and evaluated before the next application is submitted. Criminal history can also affect immigration cases. But immigration law does not simply ask, "Have you ever been arrested?" The legal analysis can depend on the exact offense, the disposition of the case, the sentence, the underlying conduct, the jurisdiction, and the applicable immigration statute. Some offenses may create inadmissibility, others may not, and certain exceptions or waivers may exist for particular circumstances. This is why an applicant should never assume it was only a misdemeanor, so immigration doesn't care. The immigration consequences of a criminal case can be different from the consequences under criminal law. A criminal record should therefore be reviewed under immigration law, not simply under the state's criminal classification. Other immigration history can create additional problems. A previous removal order, a prior unlawful entry, a previous period of unlawful presence, working without authorization, providing false information, re-entering the United States after certain immigration violations. Each fact may affect the case differently, and sometimes one immigration violation can interact with another. This is why the question, "Have you ever had an immigration problem?" is far too broad. The better questions are, when did it happen?
How did you enter? What status did you have? How long did you remain? Did you file anything? Did you receive an order? Did you leave? Did you return? What did you tell immigration officials? The details matter. Now let's return to the consular process. A family has completed the petition. The National Visa Center has processed the documents. The beneficiary attends the immigrant visa interview. And then the consular officer says, "Your case cannot be approved today." This can happen under Section 221G of the Immigration and Nationality Act. A 221G refusal does not always mean the case is permanently denied. It can mean that the application is incomplete, additional documents are required, or the case requires further administrative processing. For a family waiting abroad, this can be one of the most frustrating stages, because the petition may already be approved, and yet the immigrant visa is still not available to them. Administrative processing can take different amounts of time depending on the circumstances. There is no universal timeline. The case may require additional security checks, additional review, additional documentation, or another form of administrative processing. The important thing for families to understand is that administrative processing is not necessarily evidence that the petition was defective. The petition may remain approved. The applicant may still ultimately qualify. But the visa cannot be issued until the consular process is complete. This is one reason immigration timelines should never be presented as guaranteed dates. A case can move smoothly for months and then encounter an issue that changes the timeline. Now let's return to waivers. This is where many families misunderstand immigration law.
They hear, "There is a waiver," and assume the problem can be fixed. But a waiver is not automatic. First, the applicant must have a ground of inadmissibility for which the law actually provides a waiver. Second, the applicant must meet the eligibility requirements. Third, the evidence must satisfy the legal standard. And in some waiver categories, the applicant must establish hardship to a qualifying relative or satisfy another specific statutory requirement. The government evaluates the waiver separately from the underlying immigration petition. A family relationship can be important, but the exact relationship required by the waiver statute may be different from the relationship that qualified the person for the I-130. This is an area where individualized legal analysis can become extremely important. Let's return to Maria and Carlos. Their I-130 is approved. Their financial sponsorship is complete. The case reaches the consular stage. But during the visa process, Carlos discloses that he previously spent several years in the United States without lawful status. Now the case has changed. The family relationship has not changed. The I-130 has not changed. But Carlos's immigration history may affect his admissibility. The family now needs to understand how much unlawful presence was accumulated. When did it occur? Does a statutory bar apply? Is a waiver available? If so, which waiver? And does Carlos meet the requirements? The answer cannot be determined simply by looking at the I-130 approval. The case has entered a different area of immigration law. This example reveals a broader lesson. Family immigration is not just about the relationship between two people. It is also about the beneficiary's entire immigration history. How did the person enter the United States? What status did they hold? Did they maintain that status? Did they work without authorization? Did they ever leave? Did they ever return after a removal? Did they provide information to immigration authorities? Were they ever arrested or convicted? These questions can become important because the government evaluates the applicant as a whole, not just the family relationship that brought the case into the system. There is one mistake that can make almost every immigration problem worse: trying to hide it. A family may think, if we don't mention the old problem, maybe nobody will notice. That is a dangerous strategy. Government agencies have access to immigration records. Different applications can be compared. Previous statements can be reviewed. And an attempt to conceal a material fact can create a new immigration problem that may be more serious than the original issue. The safer principle is, identify the problem, understand the law, determine whether a remedy exists, and then respond truthfully. By now, we can see something important about the entire system. Family immigration is a chain. The family relationship is one link. The petition is another. Visa availability is another. Financial sponsorship is another. Admissibility is another. And the final immigration application is another. A problem with one link can affect the entire chain. But that does not necessarily mean the chain is broken permanently. Sometimes the problem can be corrected. Sometimes additional evidence is enough. Sometimes a waiver exists. Sometimes the applicant must wait. And sometimes the law does not provide a path forward. Understanding which situation applies is the key. When a family encounters a problem, the first step should not be panic. It should be identification. What exactly is the problem? Is it missing evidence? A filing error? A petition issue? A visa availability problem? An inadmissibility ground? A prior immigration violation? A criminal issue? Or administrative processing? Once the problem is identified, The next question is, what legal remedy, if any, exists? Some problems are administrative. Some require additional evidence. Some require a waiver. And some require a fundamentally different immigration strategy. The important thing is to understand the problem before choosing the solution. We have now followed the family immigration process from the family relationship to the petition, to visa availability, to financial sponsorship, to the final immigration pathway, and now to the obstacles that can appear along the way. But one major question remains. What happens when the beneficiary finally reaches the last stage? What happens at the interview? What documents must be brought? What questions might be asked? And what happens after the visa is approved, or after adjustment of status is approved? In the next chapter, we will follow the family through the final stage of the journey, the interview, approval, and arrival. Because after years of petitions, documents, waiting, and government review, this is where the immigration case finally becomes a new legal status.
After months, or sometimes years of petitions, documents, waiting and government review, the case eventually reaches a decisive stage. The government has the petition. It has the supporting evidence. It has the financial sponsorship. It has the beneficiary's application. And now it must answer the final question. Can this person become a lawful permanent resident of the United States? For someone adjusting status inside the United States, that decision is made through the USCIS adjustment process. For someone immigrating from abroad, the decision begins with the immigrant visa process at a US embassy or consulate. The procedures are different, but the objective is the same: to determine whether the applicant qualifies for permanent immigration to the United States. An interview should not be treated as a surprise examination. The applicant should already know what was submitted, what the petition says, what the application says, what documents support the case, and what information appears in the applicant's immigration history. For a consular case, the Department of State instructs applicants to follow the specific preparation instructions of the embassy or consulate where the interview will take place. The applicant should bring the required documents and the confirmation information requested for the interview. The exact document list can vary by case and location. That is why applicants should follow the current instructions issued for their specific embassy or consulate. For a beneficiary applying from outside the United States, the immigrant visa interview takes place at a US embassy or consulate. The consular officer reviews the applicant's case. The officer may ask questions about the applicant's identity, the family relationship, the immigration history, the application, the financial sponsorship, and any other issue relevant to visa eligibility. Digital fingerprints may also be collected as part of the process. The purpose is not simply to determine whether the applicant knows what was written on the form. The officer is evaluating whether the applicant is eligible for the immigrant visa under US immigration law. The interview may be brief, or it may involve detailed questions. The length of the interview does not necessarily determine the outcome. What matters is whether the applicant has established eligibility. Marriage-based cases can receive particular attention to the relationship itself. The officer may ask how the couple met, where they live, how often they communicate, when they married, information about family members, travel history,
and other questions relevant to the authenticity of the relationship. The applicant should not attempt to memorize a script. Real relationships are not scripts. The best preparation is familiarity with the facts and complete honesty. If the couple does not remember an exact date, it is better to say so than to invent an answer. And if there is an important issue in the immigration history, it is better to address it truthfully than to hope it will remain undiscovered. It is also important not to overestimate the interview. The officer is not starting from zero. The government already has the petition, the application, the civil documents, the financial evidence, the medical examination, and the information contained in government records. The interview is one part of a much larger adjudication. A strong interview cannot erase a statutory ground of inadmissibility, and a nervous applicant does not necessarily have a weak case. The final decision is based on the totality of the information available to the government. For applicants adjusting status inside the United States, the interview takes place through USCIS when an interview is required. The applicant may appear alone, or in a family-based case such as a marriage-based adjustment, the petitioner may also be expected to attend. The USCIS officer reviews the application and may ask questions about the applicant's eligibility, immigration history, and family relationship. The officer may also verify information that has changed since the application was filed. After reviewing the case, the government may reach several different outcomes. The case may be approved. The government may request additional evidence. The case may require additional administrative processing. The application may be denied. Or, in some circumstances, the officer may not be able to make a final decision immediately. For a consular applicant, a visa may be approved, or the case may remain refused under Section 221G, while additional processing or documentation is completed. The interview itself does not always produce an immediate final answer. Sometimes the final decision comes later. Suppose the consular officer approves the immigrant visa. The applicant's passport is returned, with the immigrant visa placed inside. This is an important moment, but there is still a distinction that every immigrant should understand. The immigrant visa is not the green card. The visa allows the person to travel to the United States and request admission as an immigrant. The person must still arrive within the visa's validity period and present themselves for inspection. The Department of State specifically warns applicants not to make irreversible financial commitments or non-refundable travel arrangements until the immigrant visa has actually been issued. An immigrant visa is not an unlimited travel document. The applicant must enter the United States and apply for admission before the visa expires. Immigrant visas are generally valid for up to 6 months from issuance, although the validity can be shorter if the medical examination expires sooner. The exact expiration date printed on the visa controls. This means that once the visa is issued, the family must pay attention to the actual date, not an estimated date, not the date they expected, the date printed on the visa. Now the beneficiary finally boards the plane. For the first time in the process, the destination is no longer an immigration office. It is the United States itself. But there is one final government agency standing between the traveler and admission: U.S. Customs and Border Protection. At the port of entry, CBP officers inspect the traveler and determine whether the person may be admitted. This is an important legal distinction. An immigrant visa allows the traveler to seek admission. It does not guarantee admission. The final decision to admit the traveler is made at the port of entry. If CBP admits the traveler as an immigrant, the legal status changes immediately. The person enters the United States as a lawful permanent resident. They are now a green card holder. They have crossed the final legal threshold in the family immigration process. The journey began with a family relationship. It moved through a petition, then visa availability, financial sponsorship, background checks, medical examination, interview, and finally, admission to the United States. This is the point at which the immigrant becomes a permanent resident. There is an important administrative step for immigrants entering with immigrant visas. USCIS requires most new immigrants to pay the USCIS immigrant fee. The fee covers processing of the immigrant visa packet and production of the permanent resident card. USCIS strongly encourages immigrants to pay the fee after receiving the immigrant visa and before traveling to the United States. The fee can also be paid after arrival. But USCIS will not issue the physical green card until the required immigrant fee has been paid. This is another example of an important distinction. Permanent resident status and the physical green card are related, but they are not exactly the same thing. The person can be admitted as a permanent resident while the physical card is still being produced. After admission and completion of the required processing, USCIS produces and mails the permanent resident card. The card is commonly called the green card. It serves as evidence of the person's lawful permanent resident status. The card contains identifying information and an expiration date. But the expiration date on the physical card should not be confused with the expiration of permanent resident status itself. In other words, a green card can expire as a document while the person's underlying permanent resident status may continue, unless that status has otherwise been terminated or abandoned under the law. This distinction becomes particularly important when we later discuss travel, renewal, and maintaining permanent residence. The new permanent resident now has a completely different legal position. They can live permanently in the United States, subject to the rules governing permanent residence. They are generally authorized to work in the United States as a permanent resident. They can travel internationally, subject to the rules governing permanent residence and abandonment. They can petition for certain qualifying relatives, and eventually, if they meet the requirements, they may become eligible to apply for US citizenship. But permanent residence also comes with responsibilities. The person must maintain the status, file taxes appropriately, avoid conduct that can create immigration consequences, and understand the rules governing extended travel outside the United States. Receiving the green card is not the end of the immigration story. It is the beginning of a new legal status. There is one important exception to understand. Some spouses and children may receive conditional permanent residence. For certain marriage-based cases, if the marriage was less than 2 years old when permanent residence was granted, the residence may be conditional. This does not mean the person is not a permanent resident. It means the residence is subject to conditions that must later be addressed. The conditions generally have to be removed through the appropriate process before the conditional period ends. This is why a family should always examine the actual immigration document received. Not every green card situation is identical. The first days and months after immigration are important. The new resident should make sure the government has the correct mailing address. They should receive the physical green card. They should understand how their social security number and employment records are handled. They should keep copies of important immigration documents, and they should understand the rules governing international travel. Permanent residence is a legal status that must be maintained. A person who simply thinks, "I have a green card, so nothing can affect me now," may eventually encounter serious problems. Permanent residence provides powerful rights, but it also carries responsibilities. Let's return one final time to Maria and Carlos. Maria is a US citizen. Carlos has completed the immigrant visa process. The National Visa Center processed the case. The financial sponsorship was accepted. Carlos attended the interview. The consular officer approved the immigrant visa. Carlos checks the visa expiration date. Maria and Carlos make their travel arrangements. Carlos pays the required USCIS immigrant fee. He boards the flight to the United States. At the airport, he presents himself to CBP. The officer reviews his documents, and Carlos is admitted as a lawful permanent resident. The case that began with a family relationship has now produced a new legal status. Carlos is no longer simply the beneficiary of a petition. He is now a lawful permanent resident of the United States. The physical green card arrives later, but the legal milestone occurred when he was admitted as a permanent resident. From the outside, family immigration can look like one enormous process. But now we can see that it is actually a sequence of specific legal steps. A family relationship, a petition, a visa category, a priority date when applicable, an immigrant visa or adjustment application, financial sponsorship, admissibility, document review, an interview, and finally, permanent residence. Each stage answers a different question, and that is one of the most important lessons of this documentary. If you understand which question the government is asking at each stage, the entire system becomes easier to understand. And yet, our documentary does not end with the green card, because becoming a permanent resident creates an entirely new chapter. How long can a permanent resident stay outside the United States? What happens if the green card expires? Can a permanent resident petition for parents? What happens to children who turn 21? When can a permanent resident apply for citizenship? What is the difference between a 10-year green card and conditional residence? And what happens if the family relationship that originally led to immigration later changes? These questions belong to the next stage of the journey. Because family-based immigration does not simply bring someone to America. It creates a legal status with rights, responsibilities, and future possibilities. The green card has arrived. For the family that spent months, or perhaps years, navigating the immigration system, this may feel like the end of the journey. Legally, however, it is the beginning of something new. The beneficiary is now a lawful permanent resident. The government is no longer deciding whether this person may immigrate. That question has been answered. Now the question becomes, how does the person maintain permanent residence? And eventually, can that permanent resident become a US citizen? A lawful permanent resident is someone who has been granted the right to live permanently in the United States under US immigration law. The person is commonly called a green card holder. Permanent residents can generally live and work in the United States. They can travel internationally, subject to the rules governing permanent residence. And they may be able to petition for certain qualifying relatives. But permanent residence is not the same as citizenship. A permanent resident does not automatically have all the rights of a US citizen. They cannot vote in federal elections. They do not hold a US passport simply because they have a green card. and their permanent resident status can, under certain circumstances, be lost or terminated. The distinction is fundamental. Permanent resident, not yet US citizen. It is also important to understand what the physical green card represents. The card is evidence of lawful permanent resident status. It is not the entire legal status itself. That distinction becomes particularly important when the physical card expires. A permanent resident may need to renew an expired card. But the expiration of the physical card does not automatically mean the person's permanent resident status has disappeared. At the same time, an expired card can create serious practical problems when traveling, working, or proving status. So, permanent residents should keep their immigration documents current and understand the difference between the expiration of a card and the termination of immigration status. The word permanent can be misleading. Permanent residence does not mean I can live anywhere in the world and keep my green card forever. The United States must remain the person's permanent home. A permanent resident can travel abroad. Short trips generally do not create a problem, but lengthy or repeated absences can raise questions about whether the person has actually abandoned US residence. The government can look at the circumstances surrounding the person's travel and their actual ties to the United States. Where do they live? Where does their family live? Where do they work? Where do they maintain their home? Where do they pay taxes? What did they intend when they left? These facts can become important. One of the most common statements about green cards is, if you stay outside the United States for less than 6 months, you're safe. That is too simplistic. There is no magic 6-month rule that guarantees permanent residence. An absence of more than 6 months can create additional scrutiny, particularly in the context of naturalization. And even shorter or repeated absences can raise questions about whether the United States remains the person's permanent home. The correct principle is, permanent residents should maintain the United States as their permanent home. Travel is allowed. Relocating one's life abroad is a different matter. What if a permanent resident knows they need to remain outside the United States for an extended period? In certain circumstances, the person can apply for a re-entry permit before leaving the United States. The application generally uses Form I-131. A re-entry permit can help demonstrate that the permanent resident intended the trip to be temporary, but it is important to understand what it does not do. A re-entry permit does not guarantee admission to the United States, and it does not automatically preserve every other immigration benefit. It can help address certain travel and abandonment concerns, but it is not a magic document that allows someone to permanently live abroad while keeping US permanent residence indefinitely. Another responsibility is often overlooked: taxes. Permanent residents generally have US tax obligations based on their status and circumstances. And filing taxes as a non-resident alien when the person is required to file as a resident can create immigration consequences. This does not mean every tax problem automatically causes loss of a green card, but it demonstrates an important principle. Immigration status does not exist in isolation. Tax records can become part of the evidence showing whether a permanent resident actually maintained their life in the United States. Now let's return to an issue we introduced earlier: conditional permanent residence. In certain marriage-based cases, if the marriage was less than 2 years old when permanent residence was granted, the person may receive conditional permanent resident status. The condition exists for a reason. Congress created this system to address concerns about marriages entered into primarily for immigration purposes. But conditional permanent residence is still lawful permanent residence. The difference is that the conditions must later be removed, and there is a very specific process for doing that. For a marriage-based conditional permanent resident, The next major immigration deadline is generally the filing of Form I-751, Petition to Remove Conditions on Residence. In a typical joint filing, the conditional resident and the petitioning spouse file together during the required filing period before the second anniversary of conditional residence. The purpose is to demonstrate that the marriage was entered into in good faith and that the legal requirements for removal of conditions have been met. But what if the marriage has ended? The law provides certain waiver possibilities. A conditional resident may, in qualifying circumstances, request a waiver of the joint filing requirement. For example, certain waivers may apply after divorce, where the marriage was entered into in good faith. Other waiver categories can apply in cases involving abuse, death of the petitioning spouse, or extreme hardship, depending on the circumstances. The key lesson is, divorce does not automatically mean the person loses the green card, but it can change the legal process for removing the conditions. The family immigration story does not necessarily stop with one person. A lawful permanent resident can become a petitioner. Permanent residents can generally petition for a spouse and unmarried children, but their sponsorship rights are more limited than those of US citizens. For example, a permanent resident cannot petition for parents or siblings through the standard family-based categories available to US citizens. This creates an interesting transition. The person who entered the United States through family sponsorship may eventually become the sponsor for another family member. The family immigration system can therefore create a chain across generations. There is another important connection to earlier chapters. When a permanent resident petitions for a spouse or unmarried child, the case may fall into a family preference category. That means the family may again encounter a priority date. The person who has just completed a long immigration journey may now discover that sponsoring another family member can involve a new wait. This is one of the reasons the immigration system can feel circular. The same family may move through different categories at different times. A US citizen may have more sponsorship options than a permanent resident, and when a permanent resident later becomes a citizen, additional family categories become available. That brings us to the next major stage: naturalization. A green card does not automatically turn into citizenship. A permanent resident who wants to become a US citizen generally must apply for naturalization. For many permanent residents, the general rule requires at least 5 years of lawful permanent residence before applying. For certain permanent residents married to and living in marital union with a US citizen, a 3-year naturalization path may be available if the statutory requirements are satisfied. But the number of years is only one requirement. The applicant must also satisfy requirements involving continuous residence, physical presence, good moral character, English and civics requirements, unless an exemption or exception applies, and other statutory conditions. One of the most important naturalization requirements is continuous residence. This is different from simply counting the number of days physically present in America. The government wants to know whether the applicant maintained the United States as their principal place of residence during the required period. Long trips abroad can interrupt or create problems with continuous residence. For the general naturalization route, an absence of 1 year or more during the required period can break continuous residence unless a qualifying exception applies. Even an absence of more than 6 months but less than 1 year can create a presumption that continuous residence was interrupted. This is why permanent residents planning extended travel should think not only about maintaining their green card, but also about how that travel may affect future citizenship eligibility. Continuous residence is not the same thing as physical presence. Physical presence asks a different question. How much time were you actually inside the United States? For the general 5-year naturalization route, the applicant generally must have been physically present in the United States for at least 30 months during the 5-year statutory period. For the 3-year spouse of a US citizen route, the general requirement is 18 months of physical presence during the 3-year period. So, an applicant could technically maintain residence, yet still have a physical presence problem. This distinction is extremely important. Residence asks where your home was. Physical presence asks where you actually were. Naturalization also requires an assessment of good moral character during the applicable statutory period, with certain conduct potentially affecting eligibility beyond that period. This can bring prior issues back into focus. Criminal history, false statements, tax problems, failure to support dependents, certain immigration violations, and other conduct can become relevant. This is another reason why the immigration journey does not simply reset when someone receives a green card. Information from the person's past may matter when they later apply for citizenship. The naturalization application is therefore another comprehensive review of the applicant's history. When a permanent resident becomes eligible to apply for citizenship, the process generally begins with Form N-400, Application for Naturalization. The application asks extensive questions: residence, travel, employment, family, immigration history, criminal history, taxes, organizations, and other information relevant to citizenship eligibility. Just as with the I-130 and I-485, accuracy matters. The N-400 becomes part of the permanent immigration record. An applicant should review the application carefully and make sure the information is complete and truthful. After filing the N-400, USCIS may schedule biometrics if required. Then comes the naturalization interview. The USCIS officer reviews the application and asks questions about the applicant's background. The applicant generally also takes the required English and civics tests unless an exemption or waiver applies. The English component can involve speaking, reading, and writing. The civics portion tests knowledge of US history and government. The purpose is not to create an academic examination. It is to determine whether the applicant meets the statutory naturalization requirements. Even an approved naturalization application does not make someone a citizen at the moment of approval. There is another final step: the oath of allegiance. At the naturalization ceremony, the new citizen takes the oath. The permanent resident card is surrendered, and the applicant receives a certificate of naturalization. This is the moment when the person becomes a US citizen through naturalization. The journey has come full circle. A family relationship once brought this person to the United States. Permanent residence followed, and now citizenship. Let's return to Maria and Carlos. Years have passed since Carlos arrived in the United States. He maintained his residence. He worked. He filed his taxes. He traveled internationally, but continued to make the United States his permanent home. His marriage to Maria continued, and eventually, Carlos reaches the point where he may qualify to apply for naturalization under the rules applicable to spouses of US citizens. He files Form N-400. USCIS reviews his history, his travel, his residence, his tax information, his background, his application. Carlos attends the naturalization interview. He completes the required tests, and eventually, he receives a notice for the oath ceremony. The green card that represented the beginning of his American life is surrendered. Carlos raises his hand. He takes the oath of allegiance, and the legal status that began with a family petition reaches its final transformation. Carlos is now a United States citizen. And now we can see the larger picture. Family immigration is not a single event. It is a cycle, A US citizen or permanent resident petitions for a family member. That person becomes a permanent resident. The new permanent resident builds a life in the United States. They may eventually become a citizen. And once they become a citizen, their ability to sponsor family members expands. The cycle can continue across generations. This is one of the defining characteristics of the American family immigration system. It is not simply about moving one person from one country to another. It is a legal system designed to reunite families and, over time, allow immigrants to become permanent members of American society. So, what does the green card really represent? It represents more than a plastic card. It represents a legal status, the right to make the United States your permanent home, the ability to work as a permanent resident, the ability to build a family and participate in American life, the possibility of eventually becoming a citizen. But it also represents responsibility, maintaining residence, following the law, meeting tax obligations, protecting the integrity of your immigration record, and understanding the conditions attached to your particular status. The green card is therefore not the end of the immigration journey. It is the beginning of permanent membership in American society. Let's now step back and look at everything we have learned. A family relationship creates the possibility of sponsorship. The I-130 establishes that relationship. The immigration category determines the legal queue. The priority date determines when a visa becomes available in preference cases. The beneficiary then follows the appropriate path: adjustment of status or consular processing. Financial sponsorship addresses the support requirement. Admissibility determines whether additional legal barriers exist. The interview and final adjudication determine whether the immigrant benefit can be granted. Admission to the United States creates permanent resident status for an immigrant visa applicant. And after years of maintaining residence, naturalization may create citizenship. What initially looked like one complicated immigration process is actually a sequence of connected legal decisions. And that is one of the most important lessons of this documentary. If you understand which question the government is asking at each stage, the entire system becomes easier to understand. We have now followed the family immigration process from beginning to end. But there is one final question. What about the families who do not fit neatly into this pathway? What about adopted children, fiancés, widows and widowers of US citizens, family members of refugees and asylees, victims of abuse, special immigrant categories? And what happens when a family member's age or marital status changes while they are waiting? The family-based immigration system is much larger than the basic journey we have followed here. In the final chapter, we will step back from the individual case and examine the system as a whole. We will look at the major family immigration categories, the most important forms, the government agencies involved, the decisions that determine how long a case takes, and the questions every family should ask before beginning the process. Because understanding immigration is not simply about knowing one form. It is about understanding how the entire system fits together. We began this documentary with what sounds like a simple question. How can a family member immigrate to the United States? Now we know that there is no single answer. The answer depends on several things. Who is the petitioner? Who is the family member? What is their relationship? Is the petitioner a US citizen or a lawful permanent resident? Is the beneficiary inside or outside the United States? Is a visa immediately available? Is the beneficiary admissible? And are there circumstances that create a special immigration pathway? The family immigration system is therefore better understood as a map of pathways rather than one road. Before choosing a form, before calculating a timeline, before looking at the Visa Bulletin, there is one question that should come first. Who is the petitioner? A US citizen has one set of family sponsorship options. A lawful permanent resident has a narrower set. That distinction can completely change the immigration pathway. A US citizen can petition for a spouse, children, parents, if the citizen is at least 21, and siblings, if the citizen is at least 21. A lawful permanent resident can generally petition for a spouse and unmarried children, but cannot use the standard family-based categories to petition for parents or siblings. So, the petitioner's immigration status is the first major branch in the map. Some family members of US citizens fall into a category known as immediate relatives. This category includes the spouse of a US citizen, an unmarried child under 21 of a US citizen, and the parent of a US citizen who is at least 21 years old. The significance of this category is enormous. Immediate relative immigrant visas are not subject to the annual numerical limits that apply to family preference categories. That means there is generally no Visa Bulletin waiting line in the same way there is for preference categories. But that does not mean the case is instantaneous. The family still has to complete the petition process, the immigrant visa or adjustment process, financial sponsorship, admissibility review, and the other requirements of the law. No annual numerical quota does not mean no processing time. Now we reach the other major part of the family system, family preference categories. These categories are subject to annual numerical limits, and because more people may qualify than there are available immigrant visas, a waiting line can develop. The major categories are F1, unmarried sons and daughters of US citizens; F2, A, spouses and unmarried children of lawful permanent residents; F2B, unmarried sons and daughters aged 21 or older of lawful permanent residents; F3, married sons and daughters of US citizens; and F4, brothers and sisters of adult US citizens. The category determines where the beneficiary stands in the system, and that category can determine whether the family waits months, years, or potentially much longer. This is where the Visa Bulletin becomes one of the most important documents in family immigration. The Department of State publishes the Visa Bulletin to show immigrant visa availability for numerically limited categories. It contains separate charts for final action dates and dates for filing. The dates can differ by category and by country of chargeability, and they can change from month to month. This is why nobody should answer, "How long will my family immigration case take?" simply by looking at the category. The country of chargeability, the priority date, and the movement of the Visa Bulletin can all matter. The priority date is one of the most important dates in a family preference case. Think of it as the beneficiary's place in the immigration queue. For many family preference cases, the priority date is established when the properly filed I-130 petition is received by USCIS. But having a priority date does not mean that an immigrant visa is immediately available. The beneficiary may have to wait until the priority date becomes current under the applicable Visa Bulletin rules. This is why two families can file similar petitions at different times and reach the final stage years apart. The petition establishes the relationship. The priority date helps establish the place in the numerical queue. The Visa Bulletin determines when that place becomes eligible for further action. Another factor can affect the weight: country of chargeability. Immigration law places numerical limits on immigrant visas, including per-country limitations. As a result, applicants from countries with especially high demand can experience different waiting times from applicants in other countries. This is why the Visa Bulletin often has separate columns for countries such as China, India, Mexico, and the Philippines.
But country of birth and country of citizenship are not always the same thing as the legal concept of chargeability. There are special rules and exceptions. So the correct question is not simply, what passport do I have? It is, which country am I chargeable to under the immigration visa allocation rules? Once a person is eligible to pursue permanent residence, there are two major pathways: adjustment of status or consular processing. Adjustment of status is generally used when an eligible person is already inside the United States and qualifies to apply for permanent residence without leaving the country. Consular processing is generally used when the beneficiary is outside the United States and applies for an immigrant visa through a U.S. embassy or consulate. The two pathways share many concepts, but the forms, government agencies, interview locations, and procedures are different. Choosing the correct pathway is therefore one of the earliest major decisions in a family immigration case. Family immigration can involve a large number of forms, but a handful appear again and again. Form I-130 establishes the qualifying family relationship. Form I-485 is generally used by an eligible person in the United States to apply for adjustment of status. Form DS-260 is the immigrant visa application used in consular processing. Form I-864 addresses financial sponsorship. Form I-601 can request certain waivers of inadmissibility. Form I-601A addresses certain provisional unlawful presence waiver situations. Form I-751 is used by eligible conditional permanent residents to request removal of conditions. And eventually, Form N-400 for naturalization. These forms are not interchangeable. Each answers a different legal question. Another reason immigration can seem confusing is that no single government agency handles the entire journey. Different agencies perform different functions. USCIS, the U.S. Citizenship and Immigration Services, handles many petitions and applications inside the United States. The Department of State manages the immigrant visa process through the National Visa Center and U.S. embassies and consulates. The Department of Homeland Security includes agencies involved in immigration enforcement and border functions. And U.S. Customs and Border Protection, or CBP, determines admission at the port of entry. The Department of State's Visa Bulletin controls the publication of visa availability dates. The system is therefore distributed across multiple agencies. Understanding which agency has the case can be just as important as understanding which form was filed. When families ask, "Why is my immigration case taking so long?" there may not be one answer. A case can be delayed because of USCIS processing times. A family preference case can be waiting for visa availability. A document may be missing. A background check may require additional processing. A medical examination may need to be completed or updated. A consular case may enter administrative processing, or the case may encounter an inadmissibility issue. The most important lesson is this:
There is no single immigration clock. There are multiple clocks. The petition clock, the visa availability clock, the document processing clock, the interview clock, the admissibility clock, and the final decision clock. A family's total timeline is the combination of these different stages. This is why estimated processing times should always be treated as estimates. A family may hear, "This takes 2 years." Another person may say, "Mine took 6 months." Neither statement necessarily predicts what will happen to a third family. Immigration cases depend on category, priority date, country of chargeability, government workload, completeness of documentation, applicant circumstances, and changes in law or policy. Even Visa Bulletin dates can move forward, remain unchanged, or sometimes move backward. That movement is called retrogression. So the immigration system must be understood as dynamic, not as a fixed calendar. Before filing anything, a family should answer a basic set of questions. Who is the petitioner? Who is the beneficiary? What is their exact qualifying relationship? Is the petitioner a citizen or permanent resident? Where is the beneficiary? Which category applies? Is the visa immediately available? What is the priority date? Which processing route applies? What forms are required? Can the sponsor meet the financial requirement? Are there admissibility concerns? Are there previous immigration violations? Are all civil documents available? Are translations required? Is a medical examination required? And finally, what happens after approval? This checklist does not replace the law, but it provides a framework for understanding the case before the paperwork begins. Immigration mistakes do not always happen during an interview. Some happen before the first form is submitted. A person chooses the wrong category. A previous marriage is overlooked. A child's age is not carefully considered. A prior immigration violation is ignored. A sponsor assumes income is sufficient. A beneficiary leaves the United States without understanding the consequences. Or a family files an application without realizing that a waiver may be necessary. Once a case enters the government system, mistakes can become harder to correct. That is why preparation is often more valuable than speed. The goal should not be file as quickly as possible. The goal should be file correctly under the right legal pathway. Many family immigration cases are straightforward enough for families to understand the basic process themselves. But some cases involve legal questions that are difficult to answer from a checklist. Prior removal, criminal history, fraud or misrepresentation, unlawful presence, multiple marriages, complicated family relationships, adoption, age-out issues, waivers, status violations, or questions about whether leaving the United States could trigger immigration consequences. In those situations, individualized legal advice can be especially important. An immigration lawyer can analyze the facts, identify potential problems, and determine what legal pathways may be available. The purpose is not to make immigration seem inaccessible. It is to recognize the difference between understanding the system and analyzing a complicated legal case. Let's compress the entire documentary into one journey. A family relationship exists. A qualifying petitioner files Form I-130. USCIS determines whether the relationship qualifies. If the category is numerically limited, the beneficiary receives a place in the visa queue. The priority date moves through the Visa Bulletin. When the case can proceed, the beneficiary applies through adjustment of status or consular processing. The government reviews the documents. The sponsor submits the affidavit of support. The beneficiary undergoes the required medical and background procedures. The government evaluates admissibility. An interview may occur. The application is approved, or the government requests more evidence, conducts additional processing, or denies the case. If an immigrant visa applicant is approved and then admitted to the United States, the person becomes a lawful permanent resident. The green card follows. Years later, if the person qualifies, naturalization may lead to citizenship. That is the family immigration journey. After following this entire journey, one thing should be clear. The US family immigration system is complicated, but it is not random. It is built around defined categories, defined relationships, defined forms, defined agencies, defined eligibility requirements, defined numerical limits, and defined procedures. The challenge is that these rules interact. A family relationship determines the category. The category can determine the waiting period. The waiting period can determine when the application can move forward. The beneficiary's history can determine admissibility. The sponsor's finances can determine whether the financial requirement is satisfied. And the applicant's actions after receiving permanent residence can determine whether that status is maintained and whether citizenship eventually becomes possible. Once those connections are understood, the system becomes much easier to navigate. This documentary has attempted to do something very specific. It has explained the architecture of family-based immigration. It has shown how the major pieces fit together, but it has not attempted to turn every possible immigration case into a simple formula. And that distinction matters. Immigration law contains exceptions, special provisions, waivers, humanitarian protections, country-specific issues, procedural rules, and changes in policy and law. The correct strategy for one family may be completely different from the correct strategy for another. So use this documentary as a map, not as a substitute for the legal analysis of a complicated individual case. And always verify current requirements with the official government agencies before filing. There is one final reality viewers should understand. Immigration law does not stand still. Forms change, fees change, Visa Bulletin dates move, processing procedures change, government policies change, and Congress can change the law itself. That means a video explaining immigration should never be treated as a permanent replacement for current information. The framework may remain useful, but the details must always be checked. Before filing a petition, before traveling, before leaving the United States, before applying for a waiver, or before assuming that a visa is available, check the current government requirements. Because in immigration, the law that applied yesterday may not be the law that applies today. So what is the single most important lesson from this documentary? It is not the name of one form. It is not the waiting time for one category. It is not even the definition of one visa. It is this. Family immigration is a sequence of legal decisions. The government first asks, is there a qualifying family relationship? Then, does this relationship fit an immigration category? Then, is a visa available? Then, can the beneficiary qualify for the immigration benefit? Then, can the financial requirements be satisfied? Then, is the beneficiary admissible? And finally, Has every requirement been satisfied for permanent residence? Once the green card is obtained, the questions continue. Can permanent residence be maintained? And eventually, does the person qualify for citizenship? Understanding those questions is the key to understanding the entire system. For millions of families around the world, the words, "I want to bring my family to America," are not merely an immigration question. They are the beginning of a long legal process. A process involving forms, documents, waiting, government agencies, interviews, financial commitments, and sometimes unexpected obstacles. But when the system is understood as a series of connected decisions, the process becomes easier to follow. You know what the petition is doing. You know why the priority date matters. You understand why some families wait longer than others. You understand why the affidavit of support matters. You understand why admissibility can become a separate issue. You understand the difference between adjustment of status and consular processing. You understand what happens at the interview. And you understand that the green card is not necessarily the final destination. It can be the beginning of a new life, and eventually, for those who qualify, the beginning of the journey toward citizenship. This is the American family immigration system. Not one form, not one interview, not one government agency, but a connected system of laws, categories, procedures, and decisions, designed to determine who may immigrate, when they may immigrate, and under what conditions. And once you understand that structure, the entire journey becomes easier to see. Family immigration is complicated, but it can be understood. Start with the relationship. Identify the category. Understand the queue. Prepare the evidence. Know the financial requirements. Check admissibility. Choose the correct pathway. Follow the process. And always verify the current law. Because immigration is not simply about reaching the United States. It is about understanding the legal path that gets you there. And that is the family immigration system.